What's up, everyone? Today I witnessed a fascinating Senate Judiciary hearing. Senator John Kennedy questioned 4 district judge nominees: LaCour, Maxwell, Chamberlin, and Lewis. The back and forth was sharp, detailed, and sometimes uncomfortable. Stick with me as I break it down. Kennedy kicked things off with a big question. What is the rational basis test? One nominee explained it's the least stringent standard courts use. If the government has any reasonable justification, the law stands.
Gentlemen, I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Kennedy pressed, what if lawmakers never gave a reason? The nominee admitted courts often have to figure out or even assume what lawmakers intended. That's when things got intense.
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic, it's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay.
Kennedy posed a hypothetical. What if a law said college grads don't need driver's tests? Sounds absurd, right? The nominee replied it would still be reviewed under the rational basis test. Kennedy.
Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay.
Pressed. So courts just invent reasoning? The nominee said that's how the Supreme Court has handled it before. A sharp reminder of how much leeway courts give legislatures. Kennedy shifted to something technical. Notice pleading versus fact pleading. One nominee stumbled, confusing jurisdiction with pleading standards. Kennedy pressed, which system does the federal judiciary use? The answer is notice pleading. But when the nominee said fact pleading, the room tensed up.
Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay.
The big constitutional question, how should judges interpret the Constitution? Kennedy asked if they agreed with interpreting it based on its original public meaning. The nominee said yes.
You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later. But when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time, I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that.
As Kennedy's time ended, he apologized for going over, admitting he missed questioning a nominee. But the message was clear. These hearings test how nominees think and handle pressure. Kennedy knows exactly how to expose weaknesses. So what do you think? Did these nominees hold their own, or did Kennedy expose some serious gaps in their knowledge? Drop your thoughts in the comments. I'd love to hear what you think. Like and subscribe for more sharp breakdowns of high-stakes political showdowns. Thanks for watching.